Hi, I'm Sara Bronin, and I created this series to help you understand the basics of property law. Today, we are talking about the fourth big question in our series, which is holding interest in property. First, a quick vocabulary note. One of the things that you may have heard in a lot of different property law lectures is this term blackacre. Many law professors use it in their lectures, and I have too. But I have since learned that the word blackacre is rooted in a pro-slavery antebellum novel with the title Whiteacre versus Blackacre. The novel used those terms to identify property owned by whites and by blacks. So when law professors use the term blackacre, they are unwittingly playing into this racialized narrative. So I've done my best to scrub my lectures of the word blackacre, one of the reasons why you won't hear it going forward in this series. All right, so today we're talking about the estates and land. When we talk about those, there are two types: the non-freehold estates, which involve tenancy interests, and the freehold estates, which involve ownership interests. The most common form of non-freehold estate is the lease, which is discussed in other videos in this series. Today, we focus on freehold estates. So there are three main types of freehold estates: the fee simple absolute, the life estate, and the defeasible fees, plural, because there's more than one of those. The fee simple absolute, also called the fee simple, is the most common type of land ownership. It lasts forever. The owner generally has full rights to transfer and to exclude and to occupy. We know something is a fee simple when we see the property is transferred to A, or to A and her heirs, or to A in fee simple. At common law, words indicating that such land was inheritable, such as to A, quote, and her heirs, end quote, were necessary to create a fee simple. The words to her heirs indicates that A's interest in the land is inheritable, as was previously required, but note that they don't give the heirs any actual interest during A's lifetime. So an important question is, when do we know who A's heirs are? We know the answer only when A dies. And the reason for that is that A is perfectly within A's rights to transfer the property to someone else before she dies, assuming that the people, so in other words, we can't assume that anybody in particular will be heirs because they might get nothing. Today, words of inheritance like to her heirs are not necessary to grant a fee simple. We presume that when a grantor transfers the entire estate, that they are doing it in fee simple, whether or not the heirs are explicitly mentioned in the grant. So that's the first kind of estate. Second kind of freehold estate we're talking about today is a life estate. We get into more details about a life estate in another video. But briefly, for these purposes, a life estate endures for the life of a named person or persons. It is a finite estate, so the finite nature, its finite length, differs from the theoretically infinite nature of fee simple ownership. So the defeasible fees, the third kind of freehold estate, also differ from fee simple, and I'd say they differ in two main ways. First, a defeasible fee may be taken away from the grantee if a condition occurs. Second, unlike the fee simple, defeasible fees create both present and future interests. Defeasible fees are also discussed in another video. So I'll leave it at that big overview of the freehold estates with previews to other videos, and I'd love to hear from you, whether on Twitter or through my website, where you can sign up to my mailing list. See you next time.